Karen Reed was framed. Her car never struck John O'Keefe.
In the Karen Reed murder trial in Boston, her defense attorney came out swinging to the jury.
The defense started out pretty strong, but what about the state? Was Karen Reed framed? I'm Lainey Law.
And I'm attorney Andrew Myers.
And this case has Massachusetts in a complete storm. Did Karen Reed kill her boyfriend? Was she framed? Were the people inside the house responsible? What has been going on in this case?
Well, this trial just started this week after a couple of years of huge controversy. At first, it was said that Karen Reed was out drinking with her boyfriend, John O'Keefe, the night before, and she had a bit to drink. He had a bit to drink. They went back to a friend's house, and Karen dropped off John O'Keefe, and apparently she went home, slept on the couch. When she woke up the next morning, there was no John. He never came home. She was actually sleeping on his couch. She made some phone calls. She ended up going back and found John dead on the front lawn of the house. And we'll get into all the details. And so the allegation at first was that Karen Reed was intoxicated and backed into John and killed him. But then the plot thickened as many people said, no, she was framed. It never happened that way. John had gone into the friend's house and they killed him accidentally or otherwise and threw his body out in the front yard. So it's a real dispute as to facts, and the defense attorney came out really strong, and we'll see how the state attorney came out in a minute.
And I think one of the things that is making this such a controversial topic is it's kind of like, are the police working against this poor woman? Is she innocent? Was this glass planted? What are the injuries? Do they match what happened? There's a lot of very conflicting feelings about this whole case.
So we start with Boston defense
attorney.
attorney.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit.
So as the plot thickens, it came out according to the very strong, I would say, opening argument that David Yedid made, that in the middle of the night, Jennifer McCabe inside the house started Googling things, and she Googled, why would anybody Google this? How long until a body dies in the cold?
Especially at a time where people would be sleeping.
2:27 was over 3 hours before anyone knew or suspected that John O'Keefe was missing or hurt or in trouble. And at 2:27 in the morning, you will learn that with no one watching her, thinking she was alone with her thoughts, and not worrying that anyone would know what she was doing, Jennifer McCabe typed in the following Google search: how long to die in the cold? Now, she misspelled the first word, so the actual search was "hoss long to die in the cold," but you'll get the point. You will ask yourself, why would somebody Google how long does it take for someone to die in the cold, unless that person knew someone who either was in that situation or would be in that situation?
Then the next kind of strange thing that was hammered into the jury by the good defense attorney was, a snowplow operator had gone by in the middle of the night. This happened during some snow, and it's that issue whether it was hard or it started out not so hard. But a snowplow operator actually remembered driving by the house in the middle of the night around 3:30, There was nobody out in the front of that house.
You'll learn that Brian Laughlin confirms that at about 2:30, when he went by that house, John O'Keefe was not on that front lawn. So you'll learn that about 2 hours after the Commonwealth claims that Karen Reed somehow incapacitated John O'Keefe, an eyewitness confirms that not only could it not have happened, but it didn't happen.
Another strong point for the defense, which was pointed out to the jury in these opening arguments, were that if you look closely at what the injuries were, the actual injuries on John O'Keefe, could it really have happened? He was a tall, large man. Could those injuries have been caused by an SUV backing into him?
You will learn that there are other major problems with the Commonwealth's theory. You'll learn that when John O'Keefe was found, he did not look like he had been hit by a car. You'll learn that he looked to have been attacked and beaten up. You'll learn that John O'Keefe was a large 6'2" man who, if positioned behind a Lexus SUV, would have had his torso completely exposed to the rear of that vehicle, including to the taillight. You'll learn that no part of his torso was injured. There was no bruising, no ridges, no scratches, no punctures. You'll learn that his chest and hips and legs were pristine, despite the Commonwealth's contention that he was hit by a 6,000-pound vehicle.
All right, Lainey, have you heard enough if you're on the jury?
Oh my gosh, it's definitely some compelling stuff. And especially at the end when he talks about the injuries sustained. We're not going to show it on this podcast because it's a bit gruesome, but a big focus is he had a lot of arm injuries, and I don't want to give away and spoil too much, but I haven't been hit by a car. I don't know what kind the injuries you'd sustain, but I can't imagine that unless someone was backing up really aggressively, it'd be hard to hit someone in a way that they're not able to get themselves back up too. I don't know. I mean, thankfully I've not been hit by a car, but if you're just backing up, you're not going like 10 miles an hour, really.
Okay, and to put the icing on the cake of the opening argument, we'll get to the state's argument in just a second, but to put the icing on the cake, there were some strange goings on with the way the investigation was handled from the very beginning, according to the defense attorney, by the lead investigator, a fellow by the name of Michael Proctor. Listen carefully to this.
Lead investigator, Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he had seized her cell phone. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet.
If proven, that is unbelievable.
And I think that's one of the signs that he's doing what we're anticipating to be a very good, strong job, because he's coming out with some very strong allegations and he's going to need to back this stuff up. So I think by kind of being shocking and saying all of this stuff, he's really setting a strong groundwork.
Yeah, and as difficult as it is to hear that, and that, you know, for those of us who have followed the case over time, that was the first time we'd heard that allegation, at least publicly, anywhere, TV, newspaper, YouTube, you name it, that the lead investigator, Michael Proctor, not only was he looking into the phone without a search warrant, which is a real no-no, but also that he was looking for nude photographs of Karen Reed. I mean, you know, we're all taught in trial law that you do not make any statements in opening arguments that you cannot prove. You've got to have a witness. You've got to have some evidence. You've got to have something to back that up. So, if you say something in an opening argument, you must put a witness on the stand or put a piece of evidence in that the jury will see to back that up. Because if you don't, now the other side will, if they're doing their job, and I'm certain they would on something like this, the other side's going to say, hey, look, the other attorney promised that he was going to show you this evidence and it never materialized. And so what about the credibility of their entire case? So if there is not a witness or some kind of evidence, maybe cell phone evidence itself, to back up that claim, it would be devastating for the defense, in my view. So you got to take all this stuff at face value, and that's certainly that does not go to any of the elements in the defense, but it certainly casts a lot of doubt or shade onto the prosecution if that's the kind of thing that they were up to. I do not know.
I definitely agree with you that just as someone that doesn't have a legal background, if I was in the jury sitting there, he's making you listen. I think that he has a lot of statements that are going to need to be backed up, but I think that he's definitely got the audience captive with this. Now we're going to have to see what comes of it, but definitely a good job.
So now the next thing we have to do in trying to be fair is to show the Commonwealth's opening arguments. The Commonwealth's attorney is a man by the name of Adam Lally. And I have to say, watching the opening arguments, I'm trying to do my job and keep my law practice going, but I'm watching the opening arguments. And I have to say that the strength of the Commonwealth's opening argument, it wasn't there. The attorney for the Commonwealth, the prosecutor, is a gentleman by the name of Adam Lally. And let's take a quick listen to what he had to say this is his opening argument.
The defendant, Karen Reed, is guilty of murder in the second degree, striking the victim, Mr. O'Keefe, with her car, knocking him back onto the ground, striking his head on the ground, causing the bleeding in his brain, swelling, and then leaving him there for several hours in a blizzard with temperatures in the teens, wind swirling around, snow piling up on his body until she comes with Mrs. McCabe and Mrs. Roberts just after 6 a.m. And that she is also guilty of vehicular manslaughter, operating under the influence of liquor, and that she is also guilty of leaving the scene after causing death.
And in the first week of the trial, the strongest evidence, which the prosecutor promised, was first responders went to the scene, and some of them say that they heard Karen Reed say, I hit him.
And at least from 3 of those firefighters, you'll hear testimony anticipates detailing statements that the defendant made to them when they had asked about the origination of some of those injuries. The defendant stated repeatedly, I hit him.
And in fact, several first responders did, in fact, go on the stand, and they said that Karen Reed said that I hit him. But then during cross-examination by Karen's own attorneys, several of them said, no, they did. When she said, I hit him, wouldn't the question be, did you hit him? What did you hit him with? How did you hit him? No, they just let it all go. They didn't say, did you hit him with your hand? Did you hit him with your car? And one of the senior paramedics actually testified that, oops, no, I didn't say that to the grand jury. And oh, by the way, no, it's not in my report. And when asked, well, that's a pretty important detail. Wouldn't you put all the important details of this case in your report? Well, yes. And why didn't you put that in your report? It was an oversight. Isn't that an important fact? I mean, if somebody that's being tried for murder or being accused of murder, and you say that you heard her say, I hit him, wouldn't you put that in your report?
Mm-hmm. Writing it down in some way is just like even saying like, oh, this person said this, to be very clear about what happened.
Another strong point for the Commonwealth is that they claim anyhow that Karen Reed changed her explanation for what happened that evening to witness Jennifer McCabe.
So initially, when the defendant is talking to Ms. McCabe, she indicates to Ms. McCabe that the last time she saw Mr. O'Keefe was at the waterfall. Eventually, as Ms. McCabe is waking up, she reminds the defendant that she not only saw them leave the waterfall around the same time as herself, but also saw the vehicle the defendant's vehicle outside of the home on Fairview Road.
Okay, so for this next one, I've got to actually look at my notes, folks. And at about 4:30, 5 o'clock in the morning on Saturday morning, June 29th, Jennifer McCabe, Carrie Roberts, and the defendant drive over to the house where she had last seen John O'Keefe. They got there. Keep in mind, it's a blizzard. It's snowing very hard. And the other two women in the vehicle, they don't see anything. So why is it, according to the Commonwealth, that Karen Reed got out of the car and she made a beeline to where the body was laying in the snow?
The defendant is the only one who sees Mr. O'Keefe. He yells and screams at Ms. Roberts to stop the vehicle. Ms. Roberts and Ms. McCabe, I anticipate, will testify that they did not see Mr. O'Keefe, not only as they were driving past him, but even after they got out of the vehicle, until the defendant gets out of the back seat and makes a beeline essentially right over to where Mr. O'Keefe's body is found.
So, all right, if again, we question whether the defense attorneys were going to be able to prove everything they said. The same thing is true of the state. The Commonwealth makes these statements and they have the burden of proof. So, they're going to have to prove all of this. Did Karen really make these contradictory stories, or were the witnesses, contradicting each other? So that's a valid question. And I've had a law license in Massachusetts for over 30 years and read the newspaper as a former reporter. I've never seen a case that has just this much emotion, this much vitriol, huge demonstrations outside the courthouse, such big demonstrations outside the courthouse that a 200-foot keep away order was instituted by the judge that spectators have to stay away from the courthouse. So I've never seen anything quite like this in Massachusetts. I guess some other states have had some huge trials like this, but this is it's unbelievable.
I think it definitely plays on, I feel like, society's feelings of like there's some kind of injustice going on here. So while both the defense and the prosecution are going to have to prove that their statements are correct, I think a lot of people feel like they've been experienced some type of injustice. So I think a lot of people feel strongly about this case in that regard. I think that as this develops, which is going to be, it's going to take a few more weeks. We're going to be at this for a while. I think it's going to be interesting to see the public's response to what's revealed and how things changed, because especially if you're saying that he's going through someone's phone without a warrant, knowing that he's not supposed to be going through the phone without a warrant, that's going to cause some really big problems, publicly.
It's really hard to know, obviously none of us were there, and it's really hard to know. I have two theories about the case, and it's just my theories. The defense has their theory, the Commonwealth has their theory. And by the way, let me ask you this before I get into my two theories. If you're a juror, now, the judge always tells the jury that the arguments of attorneys are just that, and the jurors are to make their decisions based only on the evidence. And that is now what's going to happen for the next 6 to 8 weeks with the witnesses getting on the stand, and the evidence, photographs, cell phones, maps, all the rest. So the jury is to make its determination only on the actual evidence. But jurors, in fact, do listen to opening arguments, and that's their initial impression of the case. So suppose you're on the jury, Lainey Law. What's your impression of the opening arguments?
I definitely think that the defense came out way stronger than the prosecution did. The prosecution felt almost sterile. I don't know. I think that there was definitely more of an appeal to emotion on the defense side versus with the prosecution. It didn't come off as confident, which, obviously it's not a crime to not be confident. But I think when you're trying to appeal to a jury, I think feeling secure in your statements and making those appeals to emotion and not just saying, this is what happened. And now, he did say some good things where if he's saying that she was saying, I hit him, he's going to have to prove that.
Absolutely.
But
yeah.
You already have a bunch of people on the public side. I don't know how the jury is going to be, but on the public is already thinking that everybody's in cahoots. So everybody's going to lie, like all of the prosecution sides, like the police and medics and everything. I think that even outside of the jury, on just like the public court, the court of public opinion, I think that it's going to be really hard to convince the court of general public opinion that they're just not all in like cahoots working together.
Yeah, just going on, and I guess I'm biased because I am an attorney and I've done opening arguments. I actually tried a case in that courthouse. I've done a bunch of motions in the Norfolk Superior Court in Dedham. I only ever tried one case in that courthouse. It's a historic courthouse, by the way, the historic case of Sacco and Vanzetti, who were put to their death in Massachusetts for being anarchists. That case was tried in that courthouse. Anyhow, where I was going with that was, as an attorney, I'm watching these arguments more to see, how they put their arguments together and what they were saying. And I've got to say that the Commonwealth's attorney was way outflanked by the very well prepared, polished, seasoned defense attorney, David Yannetti, who I don't know. I've never had anything to do with him, but, he's a well-known attorney. And I just felt that he was smoother. He was speaking to the jury. When you give an opening argument or any argument to a jury, you look them right in the eye. You talk to them because you want to convince them. And, it's not as convincing if somebody talks to you when they're looking down and slumping. And it seemed to me that the Commonwealth's attorney was doing a lot of that. He was looking down, checking his notes. He wasn't like I do. He wasn't really sure of what was going on. And I felt he mumbled. I mean, in that first cut,
I raised my volume. When I was listening, I raised my volume on my laptop because I was like, I can't hear him.
I didn't fiddle with the volume in the cuts, in the sound cuts, and it started out it sounded like it was in the middle of the sentence. But when we edited that, we started, at the very beginning of his statement, and I felt that the Commonwealth's attorney was mumbling. And I don't think that bodes well for them. I mean, we have no idea what's going to happen. We have no idea what's going to happen in this case, but you have to remember that the Commonwealth bears the burden of proof on each and every element of the charges. One is second-degree murder. One is manslaughter, leaving the scene of a drunk driving, death. I mean, so the Commonwealth has to prove each and every element of each of the charges, and all they need is one juror to say no, and I'm not going to change my mind. And I don't know. And
I might be mistaken with this, but aren't they going to have to prove some kind of intent on her part? Because even like if it was an accident, would it still be, manslaughter? Well,
that's an interesting point, because you're right. In second-degree murder, you've got to prove that there was intent. It can just be a fleeting, a momentary thing. But in a first-degree murder case, which this isn't, there's premeditation that's required. There's malice aforethought that's involved. So obviously they didn't charge that. They charged second-degree murder, which is a lower level of intent. But yes, you're absolutely right. It is an intentional crime. And I say it's an interesting thing that you point that out, because initially the charges against Karen Reed were motor vehicle homicide, negligent homicide. Because, the story was that she went out and she drank excessively. She had 6 drinks and a shot at the first bar. Then she went to the second bar. We don't know how much she had there. So the initial charge was drunk driving and motor vehicle homicide. That'll still get you 4 or 5 years behind bars. So those were the initial charges, and Karen Reed was arraigned in the district court. Okay, so things are riding along. She retains David Yannetti in Boston. Then all of a sudden, the Commonwealth of Massachusetts decides to take it to a grand jury, and they get an indictment on that second-degree murder charge you're talking about. Now you're talking about more serious time. Mm-hmm. And so she's staying up nights, on her laptop thinking, and she finds out about Alan Jackson, the attorney in Los Angeles, a famous attorney who has had some famous clients in Los Angeles, Hollywood people, and he's been very successful. And she says, if the Commonwealth of Massachusetts is going to ratchet this up, so am I. So that's when she brought in a second attorney who we didn't see in today's episode, but we'll see him in future episodes. Mm-hmm. So yeah, it's an interesting question that you raise. Yeah, there's a level. It's not first degree, but there is in fact a level of intent, and so that's why the prosecutors have to scratch their heads and say, to prove intent, we're going to have to show that Karen Reed or we're going to show, this is their choice, they're going to have to show that John O'Keefe and Karen Reed were having problems. Now, they had gone to Aruba, I guess about a month before this happened. And in Aruba, they fought. And Karen caught John kissing another woman. And when we say kissing, I think we're talking not about a peck of the cheek like you might give your aunt or something like that. I think it was a little bit more than that. And so Karen saw him doing that. And the prosecution apparently is also going to bring up that Karen was exploring her options, and she had dated a guy, an FBI guy. Didn't go anywhere, but at least she was exploring her options. She saw John in this kiss. They're also going to bring out testimony that the two of them argued a lot. In fact, one of the earlier witnesses, O'Keefe's brother and sister-in-law, actually did testify that they heard the two of them fighting. So, how do you prove intent when a person is in a car and backs into someone else? I mean, you can't get into somebody's head. You don't know what I'm thinking. I don't know what you're thinking. But in a situation like this, more importantly, you don't know what she was thinking. I think she was thinking, I had all those drinks. I got to get home right away.
I was going to say the only intent, and it sucks because I think also from the jury's perspective, I think how are you going to prove intent when this woman finds the body and she's screaming, crying, and going to the body? But furthermore, the only way that you're going to prove, I feel, intent with this, especially, with how bent up his arm is and everything, is taking the car, checking the car's data and saying that the car went back and forth repeatedly, because if she's been drinking, back up, something happens. Unless you're intentionally running that person over, I don't really know if there's any way that they could prove that it was done intentionally. If you're back, unless she's hitting him straight forward, which isn't the allegation, it was a bumper light. Right. That's the problem. It's just you're not intentionally running someone over at that point, unless really, how fast are you backing up? I can't imagine that you're backing up 20 plus miles an hour in a snowstorm.
Well, yeah, and that's the other issue that I think David Iannetti had brought up in his opening argument was, this was a big guy, 6'3", and weighed a lot. But also the vehicle is a large Lexus SUV that's said to weigh 6,000 pounds. It's hard to prove intent. That's why they're going back and bringing up these kissing the other woman, the arguments, and that kind of stuff. So then the question becomes, a lot of couples argue. A lot of couples don't. But a lot of couples argue. Does that mean they want to kill each other? Mm-hmm. Sometimes it does, as we know from these true crime cases. But I know couples that argue, and it means nothing, really. I have some friends that I've known for 30 years, and they argue all the time, but they're still together. So anyhow, I don't know. Do you have any closing thoughts before we head out? You know what? I'll save my two theories of the case for another episode.
You guys have to let us know that you need to hear it. I agree on my closing thoughts. I agree with you in that, how many people get cheated on and how many people kill their partner because of that. It's going to be very hard to prove intent on that. This whole thing is, I feel going to be messy. And I think that, depending on what happens, I think a lot of people, I think no matter what happens, you're going to see a lot of people upset. But that being said, thank you guys so much for watching. What do you think about our new setup? We're doing a new setup. We're getting into season 2 of our podcast. And let us know what you guys think down in the comments.
I'm surprised the dog outside the window here hasn't started barking, but that'll happen soon.
You'll see it one day.
The last time we did an episode on this case, tempers really flared. People have strong feelings. I've never met anyone that was like, oh, I don't know. People have strong feelings on both sides. So please comment. Please let us know what you think. Please let us know how you feel. Please like and subscribe. But be kind, be respectful, whether you're in the grocery store, the gas station, or in our comment section. Try not to personalize it. I've been an attorney for 30 years. I don't need to hear, if you're an attorney, how can you believe this or that? Because if you put 2 attorneys in a room, you're going to get 2 different opinions, and they're probably going to be very strong opinions. So be kind, be polite, be respectful, and be sure to join and subscribe. You have been watching About the Law, a production of the law offices of Andrew D. Myers in Methuen in the Merrimack Valley of Massachusetts and in Derry, just outside of Manchester, New Hampshire. Remember to click the like and subscribe buttons down below. And if you enjoyed this video, be sure to share it with your friends and others. If you'd like to talk to me about an injury case, a car accident, a slip and fall, a serious bodily injury case, or some other case, please feel free to contact me. I'd love to talk to you. You can contact us through my website at attorney-myers.com. We have a contact us block, or you can call on one of the telephone numbers we've given there, or you can email me at andrew@attorney-myers.com. The foregoing is offered for informational purposes only. It is not intended as and does not constitute legal advice. Laws vary widely from state to state. You should rely only on the advice given to you during a personal consultation by a local attorney thoroughly familiar with state laws and the area of practice in which your concern lies. This podcast must be and hereby is labeled advertisement in some jurisdictions. And that's that.
And that's that. No tunnels.
No tunnel. There's no tunnels in this case. That's a different case we talk about.
No tunnels. Just no.
There's no tunnels in Boston. Well, there are tons of tunnels in Boston.
Lots of tunnels in Boston.
Yeah, and I spent a lot of time in them in the MBTA, the red line, the blue line, the green line, the orange line. There's tons of tunnels.
I'm so sorry to hear that.
I don't think they have anything to do with this case, though. I don't think the tunnels really come into play. This case is just crazy, though. It's just there've been demonstrations and Turtle Boy and people just, I mean, I've never seen a case like this. There's just so many raw emotions, and you can't even have a conversation because people will yell and scream at you. So,
which is very, I feel, Massachusetts. It's kind of like when you're driving on the roads and you have 5 lanes and none of the lanes are marked out and you have to get off onto 5 different exits. Very Massachusetts. Some rotaries with no lines, some roundabouts with no lines.
I don't think people are that much better in New Hampshire. I don't think they're any better because, I mean, the roundabouts and the rotaries or whatever you want to call them. I was going to use a bad word. People just didn't think it's not, oh, you yield to the traffic that's already in there. Oh, no. It's
every
like,
man for themselves.
Who can get in there first? Can I cut you off? Can they cut me off? Who can get there's a car that's already in the rotary. Yeah, but I can come in and cut him off quick.
Listen, I'm not saying the driving's better. I'm just saying the lines are painted. I got beef with Massachusetts roads.
Yeah, well, All right, bye-bye. Have a good day.
Bye.
So now, I'm just going to keep it on only because I'm crooked. Look, I'm f***ing crooked. The camera's crooked.